Prior to our recess, I informed the parties that I would be reading my findings of fact, conclusions of law, verdict, and order on today's date. Findings of fact. The defendant was charged by trial information on October 3, 2024 with count 1, murder in the first degree, a Class A felony, in violation of Iowa Code Sections 707.1 and 707.2 sub 1 sub A. And count 2, abuse of a corpse, a Class C felony in violation of Iowa Code Sections 708.14 sub 1 sub B and sub C. The defendant entered a plea of not guilty to both charges. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. On September 22, 2024, Michele Jackson used her mother's green electric scooter to travel from her residence to Farnhamville City Park to use the swing set. Michele had an established habit of traveling via electric scooter to the same park to ride the same squeaky swing while listening to music. The defendant arrived at the park with a knife that utilized 3 different interchangeable blades that is commonly used for hunting and gutting animals. The defendant cut Michele's throat with the knife and stabbed her multiple times, resulting in her death. During the assault, the defendant received multiple cuts and lacerations to his own hand. He then dragged her body a short distance. The defendant returned to his apartment where he placed the knife handle covered in Michele's blood and hair in a garbage can located in his apartment. The defendant left blood in his apartment, on the floors, on the bathtub, and on a white towel. The defendant left his apartment and then located and retrieved a nearby rolling trash bin and placed Michele's body in it. He then rolled the trash bin a significant distance away from the park and left it by a nearby cornfield. Afterwards, he returned to the park and retrieved the scooter. At some point, the defendant placed one of Michele's shoes in the back basket of the scooter that also had a blue bungee cord attached. When Michele did not timely return to her mother, Annette's house, by 10 o'clock p.m., Annette became concerned and telephoned her older daughter, Michelle's sister, Shauna Bachman. Shauna made a loop around the park and, after finding no signs of her sister, went and picked up Annette. The 2 women continued searching and discovered the defendant in possession of the green electric scooter. The defendant gave conflicting explanations for why he was riding the scooter. Annette recognized that the scooter was her daughter's by the basket and blue bungee cord on the back. Annette called 911 and Deputy Jason McKinney was dispatched. Although he was approximately 20 miles away and did not arrive for some time. In the meantime, Shauna had called her boyfriend, Jordan Adams, who arrived at the scene with a firearm and began questioning the defendant. Soon after Jordan's arrival, Annette inspected the scooter and noticed one of Michele's shoes was in the basket and had blood on it. Jordan then aimed his gun at the defendant and ordered him to lay on the ground. Jordan held the defendant on the ground at gunpoint until the police arrived. When Deputy McKinney arrived, he turned his white lights on to illuminate the scene. He ordered Jordan to put down his firearm and to move away. He ordered the defendant to stand up, at which point everyone on the scene realized that the defendant was covered in blood. He was promptly detained. The next morning, Austin Ehrig, an employee at Landis Cooperative, noticed a rolling trash bin in an unusual location at Landis Cooperative. He opened the trash can and ultimately determined that there was a body inside. He contacted law enforcement and they retrieved the body. Law enforcement investigated Farnhamville City Park and discovered several large pools of blood, 2 earbuds, and what appeared to be the key to an electric scooter near or in the pools of blood, and drops of blood and blood paths that would suggest a body had been drugged. The police obtained search warrants for the defendant's apartment and the defendant's body. At the defendant's apartment, they discovered the knife handle in the garbage that was matted with blood and hair, as well as blood spots on the floors, bathtub, and a towel. On the defendant's person, they found a number of cuts and lacerations. In his pockets, they located extra knife blades and a separate folding knife. An autopsy was performed on Michele. The autopsy revealed that Michele suffered a large incision to her neck, 4 stab wounds to her head, 22 stab wounds to her chest and abdomen, multiple superficial stab wounds to her head, arms, and torso, and other contusions. The autopsy did not find that Michele received any defensive wounds. Michele's cause of death was deemed to be multiple sharp force injuries. Her manner of death was found to be homicide. Multiple blood samples were tested by the Iowa Division of Criminal Investigation, DCI. These tests showed that the red stains found on the defendant's shirt were blood, and that the blood matched the DNA profile of Michele. Tests of the white towel located at the defendant's residence showed that 3 of the stains were blood that contained a mixture of 2 DNA contributors. The defendant and Michele were found to be contributors to this mixture of DNA. The blood on the blade handle and the garbage was also tested, and that blood matched the DNA profile of Michele. Conclusions of law. The elements of count 1, murder in the first degree, as applies to these facts, are as follows. 1. On or about the 22nd day of September 2024 in Calhoun County, Iowa, the defendant cut the throat and stabbed Michele Jackson. 2. Michele Jackson died as a result of being cut and stabbed. 3. The defendant acted with malice aforethought. 4. Defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill Michele Jackson. The elements of count 2, abuse of a corpse, as applied to this facts, are as follows. 1. On or about the 22nd day of September 2024 in Calhoun County, Iowa, the defendant either hid the corpse of Michele Jackson or failed to disclose the known location of Michele Jackson's corpse. 2. The defendant did so with the intent to conceal a crime. The state has the burden of proof with respect to this case. The legal standard is by proof beyond a reasonable doubt. In State v. McFarland, citations omitted, the Iowa Supreme Court approved the following jury instruction with respect to the definition of reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of state's evidence in the case. If after a full and fair consideration of all the evidence in the case, you are firmly and abidedly convinced of the defendant's guilt, then you may be said to have no reasonable doubt, and in such case, you should convict the defendant. But if after a full and fair consideration of all the evidence or lack of the state's evidence in the case, you are not firmly convinced of the defendant's guilt, then you may be said to have a reasonable doubt, and in such case, you should acquit the defendant. The court, as the fact finder, must apply this standard as to the facts in this case. In doing so, the court finds beyond a reasonable doubt that on or about September 22nd, 2024, in Calhoun County, Iowa, defendant cut the throat of Michele Jackson and then stabbed her multiple times with a knife. This attack resulted in the death of Michele Jackson. The court must now consider whether the defendant acted with the malice of forethought and whether defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill Michele Jackson. Malice of forethought is defined as a fixed purpose or design to do physical harm to another that exists before the act is committed. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Malice of forethought or premeditation need not exist for any particular length of time. If a person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, the fact finder may, but is not required to, infer that the weapon was used with malice, premeditation, and in specific intent to kill. On September 22nd, 2024, the defendant went to Farnhamville City Park armed with a knife. The defendant approached Michele Jackson and cut her throat with a knife and then proceeded to stab her in the back until the blade became detached and remained lodged in her back. The defendant then continued to stab Michele with the handle and base of the knife. Prior to cutting the throat of Michele, the defendant had the opportunity to deliberate on his decision, and his ultimate decision was to attack Michele with the specific intent to kill her. The defendant's attack was premeditated, willful, and designed to do physical harm to Michele Jackson. After considering all the evidence submitted in this case, the court is convinced the defendant is guilty beyond a reasonable doubt of count 1, murder in the first degree. Regarding count 2, the court finds beyond a reasonable doubt that on or about September 22nd, 2024, in Calhoun County, Iowa, the defendant hid Michele's corpse. The evidence established that the defendant dragged Michelle's body through the park, then retrieved a rolling trash bin, put her body in the trash bin, moved the bin a significant distance from the park, and left the bin near a cornfield. The court is convinced beyond a reasonable doubt the defendant hid the corpse of Michele with the specific intent of concealing the crime of murder in the first degree. The evidence demonstrated that the defendant attempted to move the corpse soon after the murder and attempted two different methods of moving the body: dragging the body and placing the body in a rolling trash bin to move it more easily. This duality of methods of moving the bodies, as well as the significant distance the defendant ultimately moved the body, demonstrates his specific intent to conceal his crime. After considering all the evidence submitted in this case, the court is convinced the defendant is guilty beyond a reasonable doubt of the offense of count 2, abuse of a corpse. Verdict in order. The defendant is found guilty of count 1, murder in the first degree, a Class A felony in violation of Iowa Code Sections 707.1 and 707.2, Sub 1, Sub A, and count 2, abuse of a corpse, a Class C felony in violation of Iowa Code Section 708.14, Sub 1, Sub B. It is ordered that sentencing is set for August 15, 2025 at 10 o'clock a.m. in the District Courtroom of the Calhoun County Courthouse in Rockwell City, Iowa. The defendant shall be held without bond. Defendant is advised of his right to file a motion for new trial and motion and arrest of judgment pursuant to Iowa Rules of Criminal Procedure 2.24 Sub 2 and Sub 3. To be considered by the court, said motions must be filed no later than 45 days from the date of this verdict in order and at least 5 days before the date set for sentencing. The Department of Correctional Services shall prepare a pre-sentence investigation report pursuant to Iowa Code Sections 901.2 and 901.3. Is there anything further from the state? Anything further from the defense?
Your Honor, on a Class A felony, I think the code specifies that they don't prepare a PSI on that. I know there's a second count because it's a D felony, but
I ordered it because of the Class C felony conviction. I was aware of that as well, but that's why I ordered it. Any comment from the state?
Yeah, I've never dealt with where you had an A and a C. I presume that the reason for the, you don't need it from the A's is that he's going to be there and he'll have all the time they want to assess them. Plus the court won't have any discretion in sentencing. Maybe correctional services will tell you that they don't want to do it.
I think it's possible, considering that there is a chance that the motion for a new trial, or excuse me, the motion may be filed and you may change your mind as to one or the other.
that's fine. We can keep it as set, and then we'll address it for fine if we need to.
All right. Then I will leave it as is, and with that, we are adjourned.